What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we take our first look at the Brian Walshe case over in Massachusetts. So many of the same players in the Karen Reed case are involved in this case as well, but a very different situation. And I think this is going to be a good case to challenge the way we think about the criminal justice system, about the legal process, some very legitimate questions, but it's going to be a very different ride than Karen Reed, in my estimation, for how you all see the case. And today we're going to take a look at the order on the motion to suppress, which is going to give us an answer as to what is going to be cut out and thrown out as far as evidence because of police wrongdoing and what is still going to come in. But it also gives us a very good overview of the case and background of the case from the judge's perspective, not anybody else's perspective. So the information that is in this order is something that the judge legitimizes themselves and how they look at this case. So we're going to look through that. We're going to answer your questions that you have on this case because we are just now diving in to a brand new case in Canton, Mass. So before we even start reading this document, I wanted to tell you what I knew about the Brian Walshe case before I looked into it anymore. By the way, this was probably the most requested case of all of them that since we've been asking, what do you want us to talk about? This one, Aaron Spencer, some of the Madeline Soto, but that defendant just pled guilty, and then some Turtle Boy as well. So we are going to take some time. I'm probably going to do an overview on Aaron Spencer's case as well this week. That's one that interests me as I looked into it. But as far as Brian Walshe goes, here's what I know. I remember when he got arrested, connected with his wife's death. And I remember that there were some very, very, very damning Google searches. The Google searches that sound like Google searches you would expect guilty people to search. People that are accused of exactly what Brian Walshe is accused of doing. So be ready for that because we are going to hear from some of that today. And his defense team was trying to suppress some of those Google searches. So we'll see if they were successful in that. Now, Brian Walshe, it's not going to look good. We're going to look through some of these facts that look very, very bad for Brian Walshe. But we need to remember a couple things as we go into this. Number one, he is presumed innocent. Every criminal defendant that is charged, regardless of how bad it looks before they go to trial, before they're convicted or take a plea, they are presumed innocent going into that trial. So let's remember that, even with this case. And number two, he has constitutional rights. And even if he's guilty, he looks guilty, it stinks, it smells, he's a villain we have to get off the streets. If law enforcement violates his constitutional rights, there are legal remedies to those violations. Some of them are if you have an unreasonable search, an unreasonable seizure, you lie on a search warrant, you're overly broad, you break the rules, then you may not be able to use the evidence you collected after violating this person's constitutional rights. That's the scary part. That's really why we hate bad cops and we love good cops, because bad cops are the ones that let the criminals back on the streets a lot of times. Bad cops are the ones that give good lawyers the legal tools to fight something and prove and shine a light on that corruption. So here we have some bad cops. I'm just going to say, we're going to hear Proctor's name in this document for somebody that looks guilty, is presumed innocent, no doubt, but that most of the world thought is guilty. That's the sentiment online. I'll just say it that way. Okay. How will the world view this differently? Right? We had the factually innocent argument for Karen Reed that everybody discussed throughout her process. But now the lawyers are arguing that law enforcement violated his rights. He's presumed innocent. He has constitutional rights. We've got to get rid of the evidence that is the fruit of the poisonous tree. Also, folks, it's been a while since we've read a 36-page document together. So why not today? Why not now? We're going to dig in. I've got my Celsius. And we are going to dig into this. Before we do, I wanted to hit a couple of these comments. I thought were funny. Members, for the record, I sent the cookies. George B. received them. Yes, on the members only live today. Chris bet George he couldn't name a few state capitals. George hit him with an assist from me. So I will be eating one of those beautiful crumble cookies that he sent. Did you hear about the time Brian Albert cheated on his exams? He needed help from Proctor. And welcome to the new members here. You can go back and watch that members only live all about our Greece trip and George's big challenge. Okay, yes, 36 pages. You think you need coffee? What do you think I need, right? I got water and Celsius. Okay. And yeah, this is even different, by the way, for everybody that's been following the channel. This is different than the case that Lally was testifying about, which was the King case. This is the Walshe case. It's tough. It's a tough look down there. All right, here we go. Memorandum of decision and order on defendant's motion to suppress search warrants. And this is the judge, right? So the person writing this document is the judge. So the facts that they put out here, this is from the judge's point of view. The defendant, Brian Walshe, has been charged with 1 count of M, 1 count of misleading a police officer, and 1 count of unlawful conveyance of a human body. He moves this court to suppress evidence against him obtained during the execution of 13 search warrants by the Massachusetts State Police, arguing the warrants were not supported by probable cause and were impermissibly broad. There are rules. Cops know about these rules. Cops are taught about these rules. They take schooling on these rules. They have to follow these rules. If they don't follow these rules, we have problems like this. On June 18th, the court held a non-evidentiary hearing on the motion. After careful review of the warrants at issue and the arguments of the parties, the court concludes that there was probable cause to support the search warrants for the defendant's residence and electronic devices, but not for the GPS tracking of his mother's Volkswagen and for some, but not all, of the records sought from his cellular provider. For those reasons, the motion to suppress is allowed in part and denied in part. So that gives us some answers, but not everything. And also, I do want to say, just at the outset of this, a lot of times judges are put in very difficult positions where it looks really bad for a criminal defendant, but it also looks like the cops broke the rules. And sometimes they'll split the baby. Sometimes they'll say, this is good enough, because they don't want to suppress really damning evidence. But I will also say there are also other arguments you can have, like for fruit of the poisonous tree. If you are eventually going to uncover that evidence from legal ways, sometimes you can still argue it should be allowed in. So just because something gets suppressed doesn't mean you can't find another way to get it. Usually you make those arguments in the motion to suppress. But also, just because something gets suppressed, as you'll see here, it doesn't mean the case is over. Some evidence can be suppressed, and the Commonwealth can still feel they have enough to prove this case beyond a reasonable doubt. So that is important to remember as well. Just because they won part of this doesn't mean he's going to walk free. Background. There are 13 warrants challenged here. We're not going to read through each one of the warrants, but if you want to read through all the different things that they got warrants for, the court's inquiry as to the sufficiency of the warrant application always begins and ends with the 4 corners of the affidavit. The facts present to the affidavit at issue here are as follows. The Walshe residence warrant, which we know from the order the judge allowed and found it to be permissible and appropriate. There was probable cause. MSP Trooper Michael Proctor, could have said former Trooper Michael Proctor, submitted the application for the Walshe resident warrant. Proctor has 10 years of experience as a police officer and is assigned to the State Police Detective Unit at the Norfolk County District Attorney's Office. He has extensive experience investigating violent crimes and collecting crime scene evidence, and is specially trained in cellular telephone data and call records used in support of criminal investigations. Isn't that scary? I mean, this is one of those where if I was the judge, that's how I would want to write this. The Quincy District Court issued the warrant on January 8th, 23. The warrant sought a physiological evidence, including hair, skin, blood, brain matter, bodily fluid, bone, and any items that may contain their presence. B, electronic devices, including cell phones, iPads, laptops, and other devices capable of communications, custody and control, internet searches, recording, or video surveillance. Clothing and jewelry described to be worn by Anna. I think it's Anna. Anna's passport, wallet. I'm new to the case, learning the names and the pronunciation, so bear with me. Wallet and cell phone, instruments of the crime, including blunt force objects such as hammer, knife, hacksaw, trash bags, cleaning supplies, and receipts, or such items and financial documents indicating their purchase. Police executed the warrant on January 8th and 9th. The affidavit supporting the Walshe residence warrant provided the following information. So here's what they got. Oh boy. Cohasset. I'm going to need some help with that. Cohasset. On January 5th, 23, at approximately 3:45 p.m., Cohasset Police notified state police detectives that the NCDAO of a missing person and requested assistance. I'm waiting for somebody to tell me how to pronounce Cohasset. Anna. Somebody said Anna. You got it correct. So it's Cohasset. Okay. All right. Sweet. Ashley confirmed. All right, we're good. Cohasset Police requested on the day before they respond to 516 Chief Justice Cushing Highway, the Walshe residence, after receiving a call from Hugh Dunleavy, the head of security at Tishman Speyer in Washington, D.C., the employer of Anna Walshe, stating that she had not been seen since December 30th, 22. Anna split her time between Massachusetts and Washington, D.C., maintaining a residence in D.C. for work and one in Cohasset with her husband, Brian, and their 3 children. Dunleavy told Cohasset Police that Anna's vehicle was presently at her Washington, D.C. residence. Cohasset Police Officer Gregory Lawrence went to the Walshe residence on January 4th. Brian was at his house. Brian stated that his wife Anna was missing and he wanted to file a missing police report. So you're going to see a lot of things that are like, you wait till the police show up to your house to tell them that she's missing. According to Brian, Anna left the house between 6 and 7 a.m. on January 1st, taking a Lyft or an Uber to Logan Airport in Boston to return to Washington, D.C. for work. Brian had no specific flight information. He explained that despite efforts to reach her, he had not spoken to Anna since the early morning hours of January 1st. Brian had not contacted the police, but only Anna's employer, who in turn notified Cohasset Police. Cohasset Police requested and were granted a ping for Anna's cellular phone from Verizon. Cohasset Police received data from Verizon at approximately 3:30 p.m. on January 4th, indicating Anna's phone pinged in the area of the Reservoir Road in Cohasset, which encompasses the Walshe residence. The data further indicated that Anna's phone was stationary starting from the evening, December 31st, until 3:14 a.m. on January 2nd, at which time the phone went off and did not turn back on. Washington, D.C. Metro Police performed a well-being check of Anna at the D.C. residence. There was no sign of Anna there, nor any indication of foul play. Further review of Anna's employment records, including her access to employer's building, video surveillance of the parking garage, corporate credit card transactions, and phone and email activity, show no indication of any new activity by Anna on January 1st or any time thereafter. So some of this sounds like good police work, right? And we got to call it out. Some of it sounds like good police work. Camilla said, "Nobody's perfect, but MSP seems to not understand the laws of their own state. This is not acceptable. I do believe he is guilty, but evidence needs to be collected within the law." I couldn't agree more. And it sounds like they did collect some appropriately, at least according to this judge. Thank you, DF. Cohasset Police checked domestic and international flight records and found no indication Anna booked any travel on January 1st. Now, to be fair to Brian Walshe, if we're trying to look for arguments for him, she could have lied to him, right? She could have said, "I'm going to work," and she just wanted to disappear, whatever. So the fact that she didn't book a flight doesn't automatically mean he's guilty. Now, some of the other stories that he's telling are going to be very difficult for him to deal with, but when you talk to the cops, a lot of times you let it all out. Anna had booked a flight from Boston to D.C. on January 3rd, but she did not board the flight. Cohasset Police also requested records from Lyft and Uber. There were no records related to the Walshe residence or Anna's account on the relevant dates. Anna's financial records did not show any activity on January 1st or any time thereafter. Police entered Anna into the National Crime Information Center database as a missing/endangered person on January 4th. January 5th, investigators from various agencies canvassed the area in the vicinity of the Walshe residence and conducted numerous interviews. On January 6th and 7th, law enforcement conducted large-scale search and rescue operations in the area of the Walshe residence. The searches did not produce any evidence. On January 6th at 8:30 p.m., Cohasset Police Detective Schmidt and MSP Trooper DeChico, which we remember DeChico, interviewed Jem Mutlu. Mutlu had been at the Walshe residence on December 31st. He stated he arrived at the residence approximately 8:30 p.m., had dinner, champagne, and wine with Brian and Anna. No other adults were present. According to Mutlu, everyone was enjoying themselves and in a good mood. He left the Walshe residence around 1 a.m. to return home. On January 6, Brian's attorney, Tracy Minor, provided verbal and written consent to turn over Brian's cell phone and 2 Apple iPads, assuming Brian told her they're not going to find anything bad on there. MSP Lieutenant Fanning, we've got the Chico, Proctor, and Fanning so far. You guys recognize those names. Secured all 3 devices, which MSP forensically extracted the NCDAO and returned to Brian the following day. I don't know if we want to read all these footnotes. Police obtained several other search warrants during their investigation, which are not challenged by defendant. Defendant's motion states he's challenging 2 additional search warrants. However, at the hearing on the motion, defendant clarified he's only challenging the above 13. Footnote 2 is, although the court is aware Trooper Proctor is no longer part of MSP, its recitation of the factual background is as stated in the affidavit supporting the warrants. So they're like, we know. Trooper Proctor wrote the incorrect date of submission, shocker, on the Walshe residence warrant affidavit stating that he submitted on February 9th. The defendant does not argue, nor does this court find any such errors should factor into the analysis of this motion. But yet again, just another minor error from Proctor. Footnote 4, the affidavit did not provide any information about the cell phone, such as a phone number or its make model, or any further information about the Apple iPads. The information obtained in these devices is subject of another motion to suppress. See docket number 78, the motion to suppress information resulting from search for electronic data. MSP Lieutenant Fanning, okay, we got that. On January 7th, Detective Schmidt and Troopers DeChico and Proctor interviewed Brian at 1:30 p.m. at the Walshe residence. Attorney Minor was present for this interview. Woof. Brian stated that on December 31st, Anna told Brian she had to fly back to D.C. first thing in the morning, which surprised him. According to Brian, approximately 6 a.m. on January 1st, Anna was preparing to leave, giving Brian a kiss goodbye, and told him to stay in bed since he had to get up with the children soon. Anna was wearing a thin black coat, blue-gray hunter rain boots, and a black floral dress. Around 6:30 a.m., Brian and Anna's oldest child was awake and had asked Anna to fix his iPad. Later that day, around 2:30 p.m., the Walshe's nanny arrived. Shortly after 3 p.m., Brian left the Walshe residence and went to Shaw's supermarket to purchase milk and orange juice. He returned home, placed the groceries in the fridge, and left again around 4 p.m. to head to his mother's residence in Swampscott. The ride took longer than usual because Brian got lost. Normally, he would use his cell phone for GPS for directions, but one of his children had taken his phone on December 31st, and he did not find it until January 2nd, 2023. He did not know how to use the Volvo's GPS, and this is the mother's Volvo that was the subject of the search warrant that was suppressed. So we'll see what they found here. Then he took Route 114 to his mother's house. He arrived there at 5:30, stayed approximately 15 minutes, went to Swampscott Whole Foods, where he purchased frozen foods for his mother, and the CVS in Swampscott, where he purchased alcohol wipes for his mother, returned home at 8 p.m. I mean, how diabolical if he actually did do this, to like stop and go run some errands for mom right after. MSP Trooper Kotkowski reviewed video at the Swampscott and Salem CVS stores from 4:40 through 8:30 p.m. He did not observe Brian enter the stores, and neither CVS had a record of purchase of alcohol wipes on January 1st. Just kidding. I guess he didn't do it. Video footage from the Swampscott Whole Foods also did not show Brian enter the store, and neither his Chase nor Fidelity credit card showed any purchase at the Whole Foods. So you can start. Oh, great. Swampscott. Everybody's telling me I'm pronouncing that wrong. Swampscott. All right. You know it's coming, guys. I'm going to mispronounce this stuff. But yeah, so it's like he's telling a story. He's trying to create a certain footprint. Evidence is pointing to a different footprint. Okay. So we're going to just read through this and kind of see how this all develops. Swampscott, everybody's saying. Is there no P in it? There's definitely a P, but okay. All right. I'll trust you guys. We'll see. I don't know. I'm going to read it Swampscott. That's what it looks like. At least it's phonetic. During the January 7th interview, police questioned Brian on why he did not contact law enforcement about Anna being missing. He said that his phone went missing on December 31st. He emailed his mother and business partners the next day sharing the information. According to Brian, he found his phone in the 6-year-old son's bed on January 2nd. That day, he sent Anna multiple messages stating that he was worried and asking where she was. On January 2nd and 3rd, he texted family and friends asking if they heard from Anna. Brian said he did not become concerned about Anna until January 2nd. Recently, Anna had been unsearchable for about 24 hours when she was coming home for Christmas. When Brian had told her he had been concerned and almost called her work to ask about her whereabouts, Anna had instructed him not to worry and that she did not want any issues with her workplace. For this reason, Brian had not reported that Anna was missing until Cohasset police arrived at the Walshe residence on January 4th. MSP Trooper Nicholas Guarino, ding, ding, ding. We've got the Google expert, and Connor Keefe, who I believe was also involved in Karen Reed, not as highlighted as some of the other ones, conducted a forensic review of the data extracted from the iPad mini that Brian had given to Lieutenant Fanning. On January 1st, 23, Brian's cell phone was manually locked. The password for the phone was entered at 7:57 a.m., 11:24 a.m., 12:39 a.m., and 12:46 a.m. Are those supposed to be, some of those supposed to be PMs? That seems kind of weird, because wouldn't that be the next day, 12:39 a.m.? The forensic review revealed the following internet searches. Okay. So this is going to be tough for Brian Walshe to overcome. January 27, 23. Best state to divorce for a man. I'll read these footnotes. It's unclear from the affidavit whether the internet searches were extracted from the cell phone or the iPad mini. That's important. Good police work would tell you where they got this. Later warrant affidavits written by Trooper Garino clarify the police extracted the internet searches from the iPad mini, which Brian said belonged to his 6-year-old. This date is incorrectly written in the Walshe residence warrant affidavit. It is corrected later in the affidavits written by Trooper Garino as having occurred on December 27th. Yeah, because January 27th doesn't make sense. So again, these little errors are absolutely going to be picked apart by defense attorneys. But let's continue reading some of these diabolical searches. January 1st. How long before a body starts to smell? Also on January 1st. How to stop a body from decomposing? January 1st. How to embalm a body? Same day. And these are all kind of back to back to back to back to back. 10 ways to dispose of a dead body if you really needed to. Next. How long for someone to be missing to inheritance? Next. Cohasset dump. Next. Hingham dump. Next. Can you throw away body parts? Next. What does formaldehyde do? Next. How long does DNA last? Next. Can identification be made on partial human remains? Next. Dismemberment and best ways to dispose of a body. Next. How to clean blood from wood and floor. Next. Luminol to detect blood. Next. What happened when you put body parts in ammonia? Next. Is it better to throw away crime scene clothes or wash them? Now you see, it ain't looking good for Mr. Walshe. Now, even with these searches, presumption of innocence remains and his constitutional rights remain, and that's going to be tested for everybody following this case. Trooper Proctor averred that there was probable cause to believe Brian committed the crimes of kidnapping and misleading a police investigation based upon the foregoing facts, including Brian's inconsistent statements, internet searches, and the fact that Anna had not been located, nor had there been any activity from any of her accounts. Now we get to the Volkswagen warrant, and this is one that we know ends up getting suppressed. Trooper Proctor submitted the affidavit for the Volkswagen warrant. The application sought installation of GPS tracking on the vehicle registered to Diane Walshe, Brian's mother, and in the possession of Brian. The Quincy District Court issued the warrant on January 8th. The warrant affidavit set forth exact same facts as the Walshe residence warrant affidavit. It further offered information about the use of GPS surveillance tracking systems. Specifically, MSP Lieutenant David Krause, the electronic surveillance equipment technician assigned to the special services sections of the MSP, had informed Trooper Proctor that GPS surveillance systems are installed on a target vehicle without the target's knowledge, and they calculate the position utilizing satellites orbiting the Earth. Law enforcement can obtain the position of the target vehicle using mapping software through a cellular phone installed in the vehicle and may obtain current as well as historic locations of the vehicle. Based upon the facts of the affidavit, Trooper Proctor averred that there was probable cause to believe Brian had access to and the ability to operate 3 vehicles currently in the driveway of the Walshe residence, which included the Volkswagen registered to his mother, and that Brian might be a flight risk. Proctor further averred that there was probable cause to believe Brian committed the crimes of kidnapping and misleading police investigation, and the use of the GPS device would enhance the investigation by quickly identifying locations, duration of stops, and frequency of locations visited by Brian. MacBook warrant, mini warrant, all these different ones. Police recovered various electronic devices that were subject of warrants from the Walshe residence during their execution of the Walshe residence warrant. MSP Trooper Garino submitted the affidavits for the electronic device warrants. He has 17 years of law enforcement experience, specialized in this way. In Cellbrite, he's an expert in Cellbrite and extracting. He conferred with the MSP Sergeant Keefe during the investigation. Keefe also specialized in mobile devices. They hold certificates. The Quincy court issued the electronic devices warrant on January 9th. The warrant sought documents, photos, audiovisual files, electronic communication, emails, accounts, web browser history, search topics, contacts, usernames, passwords, deleted data, significant or cached location, cached location. People used to say it both ways. I love when people make fun of pronunciations. 900 hours related to disappearance of Anna, misleading police investigation. B, any user data related to the specified Apple IDs, any notes, journals, and Word text documents regarding Brian's, hold on a second. Okay, sorry, when my wife texts me like 7 times in a row, I gotta look. It was nothing big. Any notes, journals, words, text, documents regarding Brian's activities during the investigation from December 25th to January 8th, call logs from the 25th to the 8th, chats, texts, and other messages, forms of communications, applications from December 25th to January 8th, diagnostic data, et cetera, et cetera. Affidavits supporting these warrants set forth information Trooper Garino gathered during his investigation, as well as information he learned from MSP troopers. Affidavits contained all the information from the affidavit supporting the Walshe residence. On January 4th, approximately 6:35, Detective Schmidt arrived at the Walshe residence to follow up on the investigation, at which time he conducted an audio recorded interview with Brian. At the conclusion of the interview, Brian consented to a search of the house and surrounding property. Brian led Detective Schmidt around the residence and the property, identified items of potential interest in the missing person investigation. Before leaving the scene, Detective Schmidt observed the back of the 2019 Volvo bearing a Massachusetts registration 8NR793 with the third row raised. Lining the floor of the trunk area was an opaque, off-white, thin piece of plastic. The next day, Detective Schmidt went back and re-interviewed Brian. At the conclusion of the interview, Brian consented to a search of the Volvo. The third row seat was now folded down, and the floor mats were laid on the floor of the trunk. There was a light brown dirt on the floor mats. The carpet of the floor of the trunk appeared freshly vacuumed. When Detective Schmidt asked Brian where the thin plastic liner was, he stated that he had put it in the trash cans. On the morning of January 7th, Cohasset Police Detective Schmidt received an email from Richard Walker 9984 stating the following. We have the so-named Anna Walshe with us here. We had a deal worth $127,000. She messed up. We have her here with us, and if she doesn't pay the money, then she'll never be back. And we know that police and the FBI are involved. Good luck finding us. Okay, so you start to understand now, with all of this information that Brian Walshe is giving law enforcement, taking them around, you see this email sent. You start to understand where the misleading police officers' charges come in. And again, we're learning about this together and seeing how it's developed even in the judge's mind. And you can also see how when attorneys are involved and clients say one thing, you have to sometimes overrule them and say, I really don't think you should talk to law enforcement if this is your story, and this is how it ends up. On January 7th, Trooper Connor Keefe analyzed the location information extracted from Brian's cell phone utilizing Cellbrite. During an interview earlier that day, Brian told investigators that the only place he visited on January 2nd was an ice cream shop in Norwell called Press. However, location data from Brian's phone showed that on January 2nd, Brian's cell phone was at the Home Depot in Rockland until about 4:56. Now, what would he want at Home Depot? On January 8th, Trooper Moore traveled to the Rockland Home Depot to review security video from January 2nd, 23. The footage showed that between 4:12 and 4:56, Brian was pushing a shopping cart containing cleaning products, including 3 mops and brushes, 2 large clear tarps, a drop cloth, 2 rolls of heavy-duty tape, a Tyvek suit with hood, boot, and coverall, and a mop bucket with wringer. Okay. Now, could there be some explanation for these items? Sure. Could he try to tell us, hey, this is what I was planning on doing here? Sure. The problem is when you already tell the cops a story that's a lie and this is the truth, it looks a lot worse. It looks a lot worse. On January 8th, police executed the Walshe residence warrant Located in the basement was an unopened 10 by 20-foot heavy-duty canopy tarp, which appeared on an itemized receipt that Home Depot had provided Trooper Moore. Police also discovered a roll of plastic consistent with the plastic Detective Schmidt observed in the back of Brian's Volvo on January 4th. Police seized numerous electronic devices from the home, including 3 MacBooks, 2 iPhones, and 3 iPads. During the 4 occasions police interviewed Brian between January 4th and January 8th, it's never good when the cops just keep coming back for more interviews and you just keep giving more and more inconsistent statements. He gave statements regarding the trip to Whole Foods and CVS. Officers interpreted as willful attempts to mislead investigations, a la the charges. The statements wasted resources and delayed the search for Anna. Further, investigators identified multiple instances where Brian, who was on federal probation monitoring that required him to request leave of his residence, traveled to locations that he did not disclose to his probation officer. Also a big no-no. Okay, we're about a third of the way done. Let me hit a couple of these super chats. You are doing great with the Massachusetts names. As a Massachusetts gal, I'll say, we do love correcting people with our town names. It's a thing. Doesn't bother me, right? Doesn't bother me. I just try to make it something so it's not miserable for you to listen to, because whenever it makes you cringe when somebody mispronounces something over and over again. The tough part is the accent as much as pronunciation. You're doing great. Thank you so much. Says Irish Eyes. It looks like the same picture as Mary Claire, I think. Cody in Tennessee. Hit my 8th month as a member. Thank you, Peter, for this case and for all the cases you've covered. Keeps my workday entertaining. Well, Cody, we still have 24 more pages to go here, so I hope you have a lot of time at work that needs to be entertained. Tracy, nothing in Massachusetts is pronounced phonetically. Worcester is Worcester, or Worcester is Worcester. Greenwich is Greenwich. Gloucester is Gloucester. Lemonster is Lemonster. Lemonster. It is crazy funny. Yeah. And it puts my brain in a pretzel. Literally puts my brain in a pretzel. All right, here we go. Also, I know there are going to be people, just like in the Karen Reed case, that know oh so much more about this Brian Walshe case than I do. Okay. So keep that in mind that we are catching up to it now. And it's always difficult for me to know when to jump into a case, how far back to go. I'm not going to read thousands of pages to catch up on a case. That's not mine. But this was good to give us the background. We'll probably pick up. If you guys have questions on some motions or some hearings, we'll do it. If you don't, then we can move on to another case. But I'm not going to go back and read every single thing that already exists. Now, from time to time, I may pick and choose a motion here, a hearing here. But I just want to let you guys know that because I know some people get frustrated that I don't know every single fact and detail about this case. And I understand. All right. Let's knock out the next 12 pages before our next break. Based on the facts in the affidavit supporting the electronic device warrants, Guarino averred that there was probable cause to believe Brian committed the crimes of kidnapping, misleading a police investigation, and disinterring a body. Based on Guarino's training and experience, information he learned and conferred with Sergeant Keefe, the affidavit also set forth the capabilities of electronic devices and particularly Apple products. According to Guarino, they are capable of conducting internet searches, storing large amounts of data, connecting external devices via universal serial, bus cable, and Bluetooth signals. Apple computers, cell phones, and tablets have the capability of sharing files between one another using Bluetooth signals. They share iCloud accounts, logins, paired with smartwatches, fitness trackers. Guarino further averred that based on the officer's training experience, they know that people who commit criminal offenses often communicate prior to and following a crime and often communicate with their victims prior to and following a crime. People also often transport portable devices from location to location. The devices connect to various Wi-Fi connections with ease. A search of an electronic device may reveal log files and file remnants concerning communications, use of internet service accounts, as well as internet access to various websites. According to Guarino, it was reasonable to believe in this case that electronic devices were accessed to communicate with others before, during, and after the commission of suspected crimes. Lastly, Guarino averred that the historical GPS data associated with the electronic devices would contain evidence of the physical locations of the device. According to Guarino, the information and evidence associated with a particular device would contribute to identifying the locations from which the device departed, where it traveled, and the time it remained on the various coordinates. The devices would also store subscriber information as well as telephone numbers recently dialed, calls received, and information related to contacts. iPad warrant. He submitted a warrant for the iPad. They want documents, photos videos, audio, visuals. They want to look at browser history, deleted information, all the same stuff we read before. The warrant affidavit reiterated the facts from previous warrants. In addition to the internet searches occurring on December 27th and January 1st that were extracted from the iPad mini belonging to Anna and Brian's son, a search of that iPad mini revealed other searches conducted on January 2nd and 3rd. These included, brace yourself, January 2nd, hacksaw, the best tool for dismembering a body. Can you be charged with M without a body? Can you identify a body with broken teeth? What happens to hair on a dead body? What is the rate of decomposition of a body found in plastic bag compared to body found on surface of the woods? Can baking soda make a body smell good? Several of the internet searches conducted on January 1st occurred prior to the time Brian stated he received a kiss from his wife before she left the Walshe residence. The searches for how long before a body starts to smell and how to stop a body from decomposing occur less than 4 hours after the time when Anna was last seen alive at the Walshe residence by Mutlu. On January 7th, Keefe analyzed location information extracted from Brian's cell phone. It showed on January 2nd, 9:44, devices in the area of Home Goods. Surveillance footage from Norwell Home Goods showed Brian pushing a shopping cart and purchasing 3 rugs, among other items. Why do you think he would need the rugs? You can see how this case starts to fall together and how prosecutors have a lot to work with in this case. But what will be suppressed? And suppression means they can't use it at trial. Prosecutors can't use it at trial. Later that day, Trooper Moore observed video footage from Rockland Home Depot, Brian pushing several items, including 2 splash-resistant googles, a soft grip utility knife, 2 12-pound bags of baking soda, and a hatchet. Again, when you've got the Google searches, when you've got the surveillance, when you've got the receipts, when he goes to these stores and buys exactly what you would need to fix the floor, dismember the body, etc., etc. Brian's cell phone location data showed that after leaving the Home Depot, he made a trip to Derby Street in Hingham, lasting from 5:15 to 5:32. Video footage shows Brian left a jacket, black face mask, and the blue rubber gloves he was wearing while at Home Depot in his car. Walked to a trash can on Derby Street and discarded small trash bags. Location data also showed that on January 3rd, Brian's cell phone was in the area of the Claremont apartment complex in Abington from 4:27 to 4:39. Investigators observed video from that area showing a man consistent with Brian's appearance exit Brian's Volvo and walk towards a dumpster carrying a garbage bag that appeared to be of significant weight. Subsequently, at 4:48 to 4:52, the device was in the area of Point apartment complex in Abington. There was no video of the dumpster area. Brian's device then went to the area of Chatham West apartment complex in Brockton from 5:10 to 5:16. Video shows a man consistent with Brian's appearance exiting the Volvo and discarding items into the dumpster. Investigators worked to track the dumpsters at various locations, but the items had already been shredded or incinerated by the evening of January 8th. So he was partially successful in his plan, it sounded like. It's supposed to be goggles, not Googles. That's what I figured. Fruit of the poisonous tree, if they lost all the data, they'd be screwed. I agree, but they didn't. They didn't lose all the data. So you can see here, right? And this is why it's going to test everybody watching this and everybody that follows these cases. This is going to test how you feel about the laws, the rules, and cops that screw up. But also, seems like pretty good police work, right? And again, the difference in certain investigations and the evidence they have against defendants, which is why everybody was up in arms about certain cases like Karen Reed. They have where his devices are, they have videos, they have him in all these locations, the car in all these locations, and him buying and doing things that are very suspect. On January 8th, while executing the Walshe residence warrant, MSP members assigned to the crime scene services section and members of the state crime lab conducted tests on various surfaces and floors in the home. Multiple locations in the basement and the staircase leading down to the basement test positive for blood. A knife that tested positive for blood was located next to multiple bottles of hydrogen peroxide inside a cabinet above the kitchen's refrigerator. On January 8th, Detective Schmidt and Detective DeChico and Guarino interviewed Brian Walshe at the residence. Attorney Minor was present. It's like, what are you doing, Attorney Minor? During the interview, he stated on January 1st when CVS, he observed Brian on video at the Danvers CVS purchasing and shoplifting cleaning products. Interesting. The officers confronted Brian with the iPad searches about dismembering and disposing of a body conducted prior to the time that he stated he last saw Anna at the home. Brian offered no explanation other than the iPad belonged to his son. What is the lawyer doing? Why is she letting her client talk? Is minor a female? I can't remember now. He offered no explanation other than the iPad belonged to his son. Good luck with that. Trooper DeChico asked if Brian's 6-year-old son was of average intelligence. Brian stated, "I'd like to think so." When told the search had no misspelled words, he offered no explanation. Attorney, and I can attest, I have a 9-year-old boy, he would misspell some of those words. And he's very smart. When told the searches had no misspelled words, Attorney Meyer offered the possibility that Anna had performed some of the searches on the iPad herself. When asked to explain how the searches continued after Anna was said to have left the home, Brian offered no explanation. Attorney Meyer then terminated the interview. A little too late. A little too late. Like, if you're jumping in there trying to have these arguments, it's not going well for you. Like, that was a bad decision. That same day, police arrested Brian and charged him for intentionally misleading a police investigation. On January 9th, investigators executed a search warrant on the Volvo. Swabs taken from the weather mat in the trunk of the vehicle and the electronic adjustment buttons along the driver's side indicated the presence of blood. Are they going to lose that? What exactly are they going to lose from the suppressed evidence? The same day, investigators continued to review Brian's cell phone data. They observed that on January 5th, he traveled to where his mother resides, but unlike a previous visit on December 27th, this time he remained in the southwest corner of the complex near the dumpster for 5 minutes before leaving. MSP Trooper Katowski secured the dumpster. A search revealed 10 trash bags. The contents were documented, bagged as evidence, and secured. Among the items secured were towels, rags, slippers, plastic sheeting, tape, a Tyvek suit, gloves, cleaning agents, carpets, rugs, hunter boots, a Prada purse, foreign currency, Anna's COVID vaccination card, a hacksaw, a hatchet, heavy-duty cutting shears, and a hammer. The boots and purse were consistent with what Brian had described Anna as possessing when he last saw her on January 1st. Many items contained red-brown stains consistent with blood. Preliminary testing on a portion of a rug, which was heavily stained with red-brown color, showed a substance consistent with baking soda. Scrapings from the rug also revealed a metal bar with the name Gucci imprinted on it, consistent with a necklace Anna wore in photos. The state crime lab performed testing on sealed items secured from the dumpster. The slippers, the Tyvek suit, and a tissue showed the presence of DNA. Further testing of the DNA from the slippers and the sleeve cuffs of the Tyvek suit matched Anna with Brian as contributors. DNA testing of the exterior left pant leg of the interior right sleeve of the Tyvek suit and from the tissue included Anna as a contributor. The information collected during the investigation caused police to suspect that Brian killed Anna, dismembered her body in the basement of the Walshe residence, and disposed of her body and other items in various dumpsters. This information included the internet searches, untruthful statements, presence of blood in the basement, Brian's purchase of cleaning supplies and cutting instruments, the presence of blood in the rear of Brian Walsh's Volvo, video evidence of his multiple trips to 6 dumpsters in 5 days, and the items recovered from the dumpster in Swampscott. Investigators interviewed many of Anna's closest friends, colleagues, sisters, and mother. No one has heard from her since the early morning of January 1st. There was no indication that she would have voluntarily disappeared. She had made future plans for herself, professionally and personally, for her and her children. Really sad. And a lot of evidence against Brian Walshe. The story seems to make sense. Can they prove it, and can they do it appropriately without violating his rights? That's the question. Trooper Connor Keefe submitted the application for the Verizon Warrants. This is what he asked for. Both applications sought call detail records, location information, etc. The affidavit supporting the Verizon Warrants indicated Walshe used both cell phones since Anna's disappearance. For instance, according to Verizon Warrant, Bryant used that cell phone on January 2nd to make an outgoing call, and the phone was with him when he traveled to Rockland Home Depot to purchase items police believed he used to dispose of the body. According to the warrant, Brian had that phone with him on January 1st when police observed him on surveillance footage of Lowe's. getting $450 worth of tools, including a hacksaw, as well as cleaning supplies, another trip that Brian had not disclosed to investigators. The affidavit supporting the search warrant, the Verizon warrants, reiterated information that previous affidavits had. During the police interview of Mutlu on January 6th, he stated he sent Brian and Anna a message on the same text thread on January 1st. Anna never responded, and Brian responded on January 2nd, telling Mutlu his child found his phone. On January 4th, Brian called Mutlu and sounded distraught and a little off. Brian told Mutlu that he had not heard from Anna in 3 days and that she had left early in the morning for a work emergency. Mutlu asked Brian if he and Anna had an argument after he left. Brian responded something to the effect of, "Did it look like we were arguing?" Mutlu provided to the police the names of the people that knew Anna well, including her friends Alyssa Kirby and Will Fastlow. On January 7th, MSP Sergeant Yuri Buchanan, the gang's all here, and Detective Lopes traveled to Washington, D.C. and spoke to Fasto with his attorney present. Fasto, and by the way, we'll see what happens with Fasto. Just because you have your attorney present doesn't mean you're guilty of something. He was the most frequent contact with Anna on the cell phone records in possession of investigators. Fasto told investigators that he had been dating Anna for several months and that the relationship had become more serious over the past few months. Did he commit a crime? Did he do something wrong? Was it morally wrong? Was he actually a criminal? We'll see. They were open about their relationship in D.C. and had plans to celebrate the new year on January 4th when Anna returned from Massachusetts. Investigators also spoke with Kirby. She told them that Anna and Brian's marriage was strained and that Anna was planning on having the kids live with her in D.C. Anna had reportedly given some sort of ultimatum to Brian about the resolution of his federal criminal case and wanted the kids to be with her. When investigators viewed Anna's residence in D.C., they observed it to be ready for the kids to move in with their clothes and other items present. So, what is starting to build here? Motive. We start to see what the motive could have been for Brian Walshe. Again, this is a story that seems to write itself. Investigators interviewed the Walshe's nanny, Robin Howe. Howe told police that Brian asked her to watch the children on January 1st from 2 to 7. Brian had previously told Howie that he and Anna were going to a brunch that day, but when Howie arrived, he said Anna had to return to Washington, D.C. for a work emergency and had errands to do. She observed that Brian was generally calm and collected, appeared preoccupied that day. He left around 2, returned around 4 and 5 to drop off the pizza. Returned between 4 and 5. And then went out again. Howie observed one of the children had a new iPad. She said that Brian's mother, Diana, was always buying new iPhones and iPads for the children. Brian returned between 8 and 8:30. After further investigation, investigators discovered the iPhone with the phone number ending in 8028 was present at Home Goods in Norwell when Brian was seen on surveillance purchasing the rugs. Although Brian stated he lost or misplaced the iPhone 13 on December 31st and did not find it on January 2nd, till January 2nd, he had the care, custody, and control of the iPhone ending in 8028. The affidavits supporting both the Verizon warrants explained that based on Trooper Keefe's training and experience, he knows people frequently employ cell phones as a primary terms of communication. Well, I'm glad he has the expertise to explain that to us. And suspects involved in criminal behavior oftentimes require communication. Such communication is essential to evading police and disposing of evidence. Trooper Keefe believes that records related to the mobile device used by Brian ending in 8646 and 8028 are relevant to the period preceding and following Anna's M would provide evidence of planning, execution, and the cover-up. Keefe also explained, based on his training experience, can provide estimated distance between cell phone and a cell site. So he thinks it's important to talk about or to use this to establish a timeline. All right, discussion. We're about on the last third here, so let me see some comments. Rose-colored Googles. It's funny. Hearing you say, oh gosh, before trying to pronounce a mass town is so funny. LOL. I think you're doing great. You are going to be dropping your Oz soon. Drop my Oz soon. Boston RN Kate. Yeah, I just know it's coming. I always know it's coming. Why is all this in the judge's order? They're being very thorough in their background of the case and explaining why things happen. There must be a Bryantown in Mass. Too many. Truly honored you knew it was me. The Tube suddenly began using my pseudonym. Loved your channel for years now. Yes, thank you, Mary. Will you cover Vander Ark's new trial if she gets one? We'll see. Yeah, I mean, as with anything else, if people ask about it, that's why I'm looking at the Walshe case. Tons of people asked about it. That's why we're here. Hey, brother, please, a big shout out to our 10-year-old son, Cruz. Many thanks, my friend. Shout out to Cruz. 10 years old. What a great time to be alive. Mavericks 9. I love every second of it. He's literally my best friend. All right, let's get back to it. Discussion. Under the Fourth Amendment, Article 14, a search warrant may issue only a showing of probable cause. For probable cause to arise, the facts contained in an affidavit, plus the reasonable inferences that may be drawn from them, must allow the magistrate to determine that the items sought are related to the criminal activity under investigation, and that they reasonably may be expected to be located in the place to be searched at the time the search warrant issues. In dealing with probable cause, as the very name implies, courts deal with probabilities. These are not technical. They are the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. In reviewing the findings of probable cause, search warrant affidavits are to be interpreted in a realistic and common sense manner, and should be read as a whole, not parsed, severed, and subjected to hypercritical analysis. So you notice, if you thought the bar was here for search warrants, lower it all the way to here. They lower this bar as much as they can. They want to get the bad guys, right? An inference drawn from the affidavit, if not forbidden, may by some rule of law, need only be reasonable and possible. It need not be necessary or inescapable. Moreover, a reviewing court gives considerable deference to the magistrate's determination of probable cause, and even the resolution of doubt on marginal cases should be largely determined by the preference to be accorded to the warrants. So unless it's really, 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 really bad and obvious, we let it slide. Those are the rules we're dealing with, right? To me, this invites bad cops doing bad things, but it's a discussion for another day. The defendant contends that the Walshe residence warrant was not supported by probable cause because the affidavit in support of the warrant failed to establish a nexus between the items sought and any criminal activity. I disagree with that. He also argues that insofar as the warrant authorized the seizure of all electronic devices in the Walshe residence is impermissibly broad. Let's read that footnote. The defendant's memorandum in support of his motion also contends that the evidence and information seized from the consented to searches of the defendant's iPhone and his son's iPad mini should be excised from the affidavit in support of the search warrant. As stated in footnote 5 infra, the court has denied the defendant's separate motion based on lack of consent. Accordingly, there is no basis to excise such information from the warrant affidavits. Yeah, it's going to be hard to say I didn't give consent, or it wasn't voluntary, it wasn't knowing, when like your lawyer is there with these interviews and you giving consent and discussing the things they found in the Google searches they found with you while your lawyer's present. And like you and your lawyer arguing with the cops. That's why it's like, I got a lawyer, nothing. And it's like, I didn't know what I was doing. You know, I didn't voluntarily give those. I felt like I had to. I felt like you forced to. That argument works a lot better when you're not giving a bunch of interviews with your lawyer. Based on careful review of the warrant affidavit, the court concludes there was probable cause to search the Walshe residence for the specific items, including all electronic devices. As to the defendant's first contention, it is well established that the affidavit submitted with the search warrant application must provide a substantial basis to conclude that the items sought are related to the criminal activity under investigation and that they reasonably may be expected to be located in the places to be searched at the time the warrant is issued. Stated differently, the government must not only show that there is probable cause that the individual committed a crime, but also there's a nexus, which is a connection between the alleged crime and the article to be searched or seized. The affidavit here showed that Brian had not contacted police, even though his wife had been missing for several days, and that his account of what occurred on January 1st did not match the other information investigators had obtained. Now, let's be careful about what this is and what this is not. Number one, just because the judge is saying this and stating it as a fact doesn't mean that the judge thinks Brian Walshe is guilty. What the judge is looking at is if these facts are true and the information the cops had at the time and they provided them to the magistrate, is that probable cause? That's why the language sounds conclusory, like the judge has made up their mind. There was no evidence Anna had left the residence. in an Uber or Lyft to Washington, D.C., as Brian claimed, or that she ever planned to do so. And surveillance footage and store records contradicted Brian's statements. The defendant's false statements to police and concealment of information contributed to probable cause analysis of whether he was involved in a crime. That makes sense, right? They definitely had probable cause. Additionally, police discovered several internet searches made following Anna's disappearance on Brian's son's iPad mini regarding ways to dispose of a dead body and clean up a crime scene. Taken together, this information was sufficient to establish probable cause to believe that the defendant was involved in Anna's disappearance and misleading police, therefore had committed the crimes of kidnapping and misleading police. So you understand that if that evidence is not going to get suppressed, if those Google searches, what he turned over voluntarily, what was searched in the Walshe residence, if that's not going to get suppressed, you can suppress a lot of information and evidence, and the Commonwealth still probably has enough based on his own statements and contradicting and surveillance showing what he was doing when he said he was doing something else. Still a lot of evidence there. The affidavit also establishes a nexus between these crimes and items sought, including physiological evidence, items belonging to Anna, such as her clothing, jewelry, etc., and instruments of the crime described. It is reasonable to infer from the affidavit Brian, the only adult in the home at the time the internet searches concerning the dismembering and disposing of and cleaning up after a dead body occurred, performed those searches. Thus, there was probable cause to believe that physiological evidence would be found in the Walshe residence, as well as the tools and cleaning supplies necessary to perform the actions identified in the internet searches. In the memorandum, the defendant separately argues that there is no probable cause for the items listed under Section E, instruments of the crime listed in the iPad search of the affidavit, blunt force trauma, knife, hacksaw, trash bags, etc. This argument appears only to apply if the court suppressed the internet searches due to lack of consent, which, as noted herein, the court has not. Okay. So it's like the stuff you voluntarily gave over, it's going to be pretty hard for us to suppress that. The affidavit also explained that Brian was using electronic devices to make internet searches directly related to Anna's disappearance and to communicate about her disappearance in the time before police were aware she was even missing. Therefore, there was probable cause to believe that there would be some evidence of the crimes on the devices. Further, there was no evidence that Anna had left the home or her phone pinged in the area of the home after she went missing. There was probable cause to believe that the clothing she was allegedly wearing when she was last seen and her passport, wallet, and cell phone, as well as other items sought in the warrant, would be found at the Walshe residence. Accordingly, the defendant's first contention fails. With regard to the second argument, the warrant's authorization to seize all electronic data was not impermissibly broad. The fact that the internet searches about dismembering and disposing a body appeared on the defendant's son's iPad mini is significant. It was reasonable for police to infer that Brian made those searches on his son's device or on another Apple device synced with that iPad. In either case, officers could further infer that Brian used various electronic devices to which he had access in an effort to cover up his crime. Also, the affidavit set forth that Brian was using his phone as well as some other electronic devices to communicate about Anna's whereabouts. Brian told the investigators that while his phone was missing from December 31st, 22 to January 2nd, he had emailed his mother and business partners to tell them that Anna was missing. He further explained that upon locating his phone, he had texted Anna multiple times and reached out to her friends and family to inquire if they had heard from her. And he had contacted Anna's work about not being able to get in touch with her. Thus, Brian was using more than one electronic device to communicate with Anna during the time she was missing. Based on the information in the affidavit, police had probable cause to believe that Brian was using electronic devices he had access to in the Walshe residence to affect the investigation into Anna's disappearance. Where the officers could not know which electronic devices held such information, the warrant authorizing the seizure of all electronic devices was not overly broad. So it's like, do you really need the kids' devices? Do you really need this? Well, by him saying he lost his phone, it probably opened up relevance to more electronic devices than would otherwise be relevant in a case like this. And it seems like that's the way the judge made their decision. Warrant seeking evidence of defendant's mental state, not overly broad, where police did not have information that would allow them to further limit the description of this category of items. It's a pretty broad ruling they used there. Thus, the defendant's second argument is also unavailing. Accordingly, there is no basis to suppress the evidence seized pursuant to the Walshe warrant. All right, the Volkswagen warrant. This we know was at least partially suppressed. So what evidence did they lose because of bad police work? The defendant challenges the warrant authorizing police to install a GPS tracking device on the 2013 Volkswagen Beetle registered to Brian's mother. The court agrees there was no probable cause for this warrant. The surreptitious installation of a GPS device on a motor vehicle is a search or a seizure and thus requires a search warrant. Warrants for GPS monitoring of a vehicle may be issued under the court's common law authority in circumstances where there is probable cause to believe that a particularly described offense has been, is being, or is about to be committed, and that GPS monitoring of this vehicle will produce evidence such as of such offense, or will aid in the apprehension of a person to the applicant has probable cause to believe has committed, is committing, or is about to commit such offense. The warrant at issue does not meet this standard. The warrant authorized the GPS tracking of the Volkswagen for 15 days from the date of its issuance, January 18th. However, the affidavit supporting the warrant did not offer any information as to how monitoring the Volkswagen would produce evidence of Brian's alleged kidnapping of Anna or his misleading a police investigation or aid in his apprehension of such crimes. Other than stating that the Volkswagen was currently parked in the driveway of the Walshe residence and that Brian had access to and the ability to operate it. There was no information in the affidavit connecting the vehicle to Brian or the crimes. While the affiant averred that having access to 3 vehicles suggested Brian might be a flight risk, there was no facts in the affidavit from which it can be inferred that Brian was considering flight. Nor is it clear to the court how having access to more than one vehicle increases a suspect's risk of flight. Because the affidavit supporting the Volkswagen was not supported by probable cause, the court will suppress any evidence obtained from that warrant. The electronic devices warrants, so they didn't put exactly what's going to be suppressed here, so maybe we can connect it with some of the other information in the document. During the execution of the Walshe residence warrant, police seized several electronic devices, which each became the subject of their own warrant. Much later in the investigation, police obtained a warrant for the iPad, a device obtained from Anna's residence in Washington, D.C. Defendant argued that 1, all the affidavits supporting these warrants lack specific evidence linking the electronic devices to criminal conduct. 2, that the affidavits impermissibly rely on the general presence of cell phones in daily life and officer experience. And 3, they are overly broad in terms of the time frame the items sought. None of these arguments have any merit. To establish probable cause, okay, we know this, of a computer-like device, police must first obtain information that establishes the existence of particularized evidence related to the crime that they believe is likely to be found on the device in question. Turning to the defendant's first contention, for largely the same reason listed in Section 1, discussing the Walshe resident warrant, the affidavits of the electronic devices warrants contain sufficient specific evidence linking Brian's electronic devices to the accused of criminal conduct. And you can see the difference here between the Volkswagen, putting it on a vehicle, more invasive search and seizure, a vehicle that was not used from that day going forward to commit another crime or in furtherance of a crime or about to commit a crime. It being a flight risk was not enough probable cause to get the affidavit on that vehicle. And you notice to me, this is a major loss for the defense. I heard it being touted as a major win for them, and it is bad for cops. And it shows to me they're willing to do certain things and willing to overreach to get warrants like the Volkswagen because they're like, we'll probably win more than we lose, right? We're not going to lose all these search warrants. They're not going to suppress all the evidence we got, so we might as well stretch and push. To me, that's what this is an indication of. More bad police work by these cops. But they did have probable cause for the vast majority of the damning and material evidence against Brian Walshe. That's kind of my overarching thought of most of this order. He used more than one device to send emails, calls. He used it in furtherance of his crimes. The affidavits explain how Apple electronic devices can share information between multiple devices. Thus, the affidavits established probable cause to believe Brian's electronic devices would contain evidence of Anna's disappearance and Brian's efforts to mislead the police investigation. As to the defendant's second argument, the affidavit did not, as he contends, rely on general evidence about cell phones and officer experience. Rather, as noted above, they were provided detailed information regarding how police believed Brian used the electronic devices in the commission of the crimes and why they believed the information sought would be on his electronic devices. Affidavit that did not provide probable cause to search the defendant's cell phone, where the only connection between the cell phone and the crime was the affiant's conclusory statement that cellular telephones contain multiple modes used to store vast amounts of electronic data, and that there was probable cause to believe the defendant's cell phone and its associated accounts will likely contain information. So they're saying this was too broad, but the affidavits in this case were much more specific than that. With regards to the defendant's last contention, these items sought in the electronic devices warrants were not overly broad. To be sure, the warrants authorized the search of a significant amount of information from the devices. So it was broad, but it wasn't overly broad, the court says, and that's a difference. You can have broad search warrants, but they can't be overly broad. They have to be narrowly tailored to the crime, the nexus, the connection, the probable cause. This included all communication, emails, texts, etc., browser search history, photos, videos, audio files, location data, text documents, health data, user data related to specific Apple IDs, and information related to the ownership, custody, and control of the evidence sought. And I will tell you, Brian Walsh's own statements provided so much probable cause for law enforcement and for the court to look at now that that's kind of insurmountable when it comes to a lot of this. Because of what he said, because of the lies he told, that makes it so much more broad about how we can disprove what he said, Judge. He lied. Why is he lying? Let's see where he is. He's throwing stuff away. It goes with his Google searches, and it just grows and grows and grows. Moreover, the warrants were limited in scope to items that related to the disappearance of Anna Walshe and misleading a police investigation. That misleading of the police investigation is very broad, or related to Brian Walsh's activities regarding the investigation. As such, the warrants were clear about what they were seeking on the devices and specifically identified the types of evidence sought, and so were not overly broad in scope. A warrant may be broad in that it authorizes the government to search an unidentified location or object for a wide range of potentially relevant material without violating the particularity requirement. That's kind of what I was just saying before. He clearly never watched Dexter, or he watched just enough to be dangerous, right? It's like he watched, he's like, I think I could do this, but not enough to where he had to Google all this stuff, and definitely not enough to actually cover his tracks appropriately. I mean, this looks bad, folks. This looks bad. I'm sorry I'm not able to get as many comments up on the screen whenever I'm reading a document straight. It's hard for me to follow the chat and read the document at the same time. I try to do it as best as I can, but it's imperfect. John and Kelsey, if you want to star a few questions here, I've got only 5 or 6 pages left. Then I can answer everybody's questions they have at the end. The defendant's challenge to the breadth of the time frame similarly falls. To be sufficiently particular, a warrant for cell phone searches or electronic devices presumptively must contain some temporal limit. You can't ask for his cell phone information for all of time. Determining the permissible parameters for a cell phone search is a fact-intensive inquiry and must be resolved based on the particular facts of each case. The inquiry can be based on the type of crime, the nature of the evidence sought, and normal inferences about how far back in time the evidence could be found. Here, the time frame was within permissible parameters. Give me 1 second. The electronic device warrants were limited between the time of December 25th and January 8th, or in the case of the health data, December 31st and January 8th. That makes sense, right? Based on what we know. Based on the facts of this case, there was nothing overly expansive about these timeframes. As to the time period between January 1st, January 8th, the affidavits articulated a reasonable belief by police that Brian was engaging in efforts to mislead the police in their investigation into Anna's disappearance by, among other things, giving police false information about what he was doing and where he was going during the time period, and engaging in efforts to get rid of evidence. So what is that? His own statements damning him, sinking him, providing probable cause, allowing these broad search warrants and affidavits to be filed. Moreover, Anna's body had not yet been located, and as discussed herein, police had reason to believe the evidence of what happened to her and Brian's actions since her disappearance would be found in the specially specifically articulated evidence sought on his devices. As to the days prior to January 1st, okay? So then they're like, well, can we at least suppress the stuff from December 25th to the 1st? Police had reason to believe that Brian and Anna were having marital troubles before her disappearance. When you interview somebody that says, I've been dating Anna for months, it's like, well, maybe did Brian Walshe know about this? Did he indicate any strife, any fighting, any problems between them? The affidavits noted that although Brian had told police there was no marital discord between him and Anna, on December 27th, Brian had searched for the best date to divorce for a man. Probable cause. It's like that Jordan meme. Feels like probable cause. Moreover, the affidavits explained that Anna had come back to Massachusetts around Christmas and then gone back to DC and then returned again to Massachusetts right before December 31st, 2022. Given the general use of cell phones as articulated in the affidavit and Brian and Anna's relationship, it was reasonable to infer that there would be communications between them leading up to New Year's Eve. There was therefore probable cause to believe that evidence as to the reasons for Anna's disappearance would be found in the days leading up to January 1st. And again, they didn't ask for the whole year. And the inclusion of the 5 days prior to Anna's disappearance as part of the temporal time was not overly expansive. Although the defendant makes no specific argument as to the iPad warrant, there is no question the warrant was also supported by probable cause. Police obtained the iPad search warrant on March 9th. Well into the investigation, as such, it contained more evidence supporting the probable cause to believe Brian killed and dismembered Anna's body and misled police about what had occurred, and had more information about what had been found on Brian's electronic devices already searched. The iPad warrant primarily sought communications or records contained on the device between Brian and Anna relating to their states of mind or motive, as well as browser history, location data, and other documentary evidence related to Anna's disappearance and M. To the extent that the defendant is challenging the expanded time frame of the warrant from November 17th to January 7th, given the evidence police had implicating Brian in the crimes as articulated in the supporting affidavit, there was substantial basis to believe evidence related to the crimes would be recovered in the expanded time frame. I tend to agree. I would say whenever, what's his name? I can't remember the guy's name that was cheating with her, having an affair in DC. I would say that whole relationship. What did Brian know? What did he see? What did he find? That could lead to and prove the motive in this case. The defendant challenges the 2 warrants for Verizon records pertaining to the CSLI and location data for the 2 iPhones he used. He contends that the time periods requested for the data from the 30th to the 8th and the number ending in 8646 from January 1st to the 8th for the number ending in 8028 are unreasonably large amounts and amount to unlawful general warrant. The court agrees with the defendant only to the extent that the Verizon number 8646 warrant sought CSLI data for December 30th and 31st. The time periods sought were otherwise permissible. This is technical wins, right? An affidavit in support of the search warrant for historical CSLI must demonstrate probable cause to believe that a particularly described offense has been, is being, or is about to be committed, and the CSLI being sought will produce evidence of such offense or will aid in the apprehension of a person who the applicant has probable cause to believe has committed, is committing, or is about to commit an offense. The Supreme Judicial Court has recognized that defining the permissible parameters of time for CSLI searches that are justified by probable cause is difficult. This is a fact-intensive inquiry and must be resolved based on the particular facts of each case. There is no question here that the affidavit supporting the Verizon warrants provided probable cause to believe the defendant had committed crimes alleged. The affidavits contained additional information regarding Brian's purchase of tools such as a hacksaw, police observations of Brian discarding items in various dumpsters, items police recovered from the Swampscott dumpster, Brian and Anna's strained relationship, and Brian's attempt to mislead the investigation into her disappearance. The affidavits further stated that Brian used both cell phones during the relevant time frame when Anna went missing and the police commenced their investigation. Where cell phones have become an indispensable part of daily life and exist as almost permanent attachments to their users' bodies, it may generally be inferred that the location data from a particular phone will yield the suspect's location at any given time. Therefore, an affidavit establishing that a suspect committed a crime and that the suspect was known to own or use a particular cell phone provides the requisite basis to believe the location data will provide evidence of the suspect's participation or lack thereof in the suspected criminal activity. Insofar as the warrants sought CSLI data from January 1st to the 8th, the time frame was not impermissibly expansive. The information in the affidavit outlined Brian's actions from January 1st to the 8th. During that time, Brian bought tools and cleaning supplies that could be used to dismember, dispose of, and clean up after a body, and went to dumpsters in various apartment complexes to discard bags, including his mother's complex, where police later recovered items belonging to Anna and items stained with what appeared to be blood. Further, during interviews with investigators, the last of which occurred on January 7th, Brian continually gave police false information about where he had gone in the days after Anna's disappearance, and police still had not recovered Anna's body as of January 8th, 2023, given that police had probable cause to believe Brian was responsible for Anna's disappearance on January 1st, 2023, and that he had spent the days between then and his arrest attempting to cover up his crimes and mislead the police investigation. There was probable cause to believe the location data from Brian's phone records from January 1st to the 8th would yield evidence of his involvement with the crimes. However, with regards to 2 additional days, the 30th and the 31st, sought in the Verizon warrant, there was no probable cause to believe the CSLI data from those dates would contain evidence of the offenses. Why? Can you guys answer why before I read it? They want to know his location. Was he committing crimes? Was he covering it up? Was he misleading police? Was he committing crimes those days, January 1st to the 8th? What's the difference between the 30th and 31st, right? They could get more information about his location. Was he committing crime those days? Was he setting up, planning for crimes? There is nothing in the affidavit suggesting that police had any reason to believe that a crime occurred before that point. Thus, there was no substantial basis to believe that the device would contain relevant evidence of the crime, that is, the defendant's location at or around the time the crime was committed. So, specifically, location data from his phone was not relevant on the 30th or the 31st to prove that he was committing a crime, because we know from Mutlu, the friend that was over their house, that Anna was still alive on the 30th and the 31st. So Brian Walshe was not committing the crime to end her life, dismember her body, or mislead law enforcement on the 30th and the 31st. Now, that's different when it comes to searches and text messages, things like that. But specifically the location information, they're not going to be able to use it from the 30th and 31st. It's a win technically for the defense. It's cops overreaching, doing too much, going where they shouldn't go, asking for forgiveness and not permission. But what is the suppression of that evidence really going to do? How much is that really going to hurt the Commonwealth's case here? You tell me what you think. Because there was only probable cause to support the Verizon warrants for the period of time from January 1st to the 8th, the court will sever the warrant and suppress any CSLI and location data obtained from December 30th and December 31st. Severance of the valid portion of a search warrant where a part of the warrant was proper remedy for overly broad CSLI warrant. So it is proper. It's a proper remedy, a proper fix to sever and say you can have everything after January 1st, but not before. For the foregoing reasons, defendant most express is allowed as to these search warrants and is allowed to these search warrants, but it's denied for everything else, including the vast majority of the material evidence they have against Brian Walshe. So, how do we look at police overreach or police potentially violating the rights, the constitutional rights of criminal defendants that seem to have a mountain of evidence against them? Criminal defendants, you may be sitting there right now as a viewer thinking, this person's guilty. Do the same rules apply? Do we still want to protect those criminal defendants? Are they still presumed innocent? Do they still have constitutional rights? The answer is absolutely yes. We must still presume them innocent. We must still protect their constitutional rights. We must still suppress evidence, just like the court did in this case, if there was overreaching by law enforcement, if there was not probable cause for search warrants for information they want to gather, it must be suppressed. The Commonwealth must not be able to use it. Now, with that being said, and the defense did have some minor victories here, getting some evidence suppressed and showing law enforcement didn't do their job correctly in requesting certain information, the vast majority of material evidence that looks very damning at this point against Brian Walshe is still in play, will still be used by the Commonwealth in their attempt to seek justice for Anna Walshe and convict Brian Walshe, whom they believe to be guilty at this point. And I know many people out there watching and looking at this case believe to be guilty, but as we continue to look, and I've heard rumblings, they're still looking for Proctor's text. Is there anything about this case? The defense isn't done going after law enforcement in this case. DeChico, Guarino, Guarino, Proctor, all sorts of the same law enforcement officers that we saw in Karen Reed's case. See here. And will there be more misconduct? Will there be more fruit of the poisonous tree? I don't know. But as we're looking at this order by the court, I didn't watch the hearing, but I tend to agree, unless the court misrepresented some facts or arguments, I tend to agree with a lot of what the court said here. And you can hear from the court's tone, they're not hammering law enforcement. They're not saying, you did a horrible job, you guys, you overreached or tried to go in places you know you shouldn't have. It didn't seem or feel like that. Nancy, if MSP went to the Home Depot because of location data obtained with our consent or warrant, should MSP have to indicate what led them there? With our consent. If you consented, if somebody consents to it, that's usually pretty good evidence of what they need. But they should still always indicate where they got the information from. Why did they stop looking at the searches, then get a search warrant if the searches were legal? So you'll see law enforcement do that a lot to kind of, and it's almost what I argued before, right? It's like, we got this information, but even if we did it the wrong way, we would have eventually discovered it by doing it the right way. So he consented, he gave us, we could search, but we also want to do a search warrant because we have probable cause. So we get the search warrant. So now they have two reasons they could look at these searches, so that if a court would have said that consent was not voluntary, you forced him to do it, well, they could say, well, Judge, we also had probable cause to get the search warrant for it as well. Question, do you find it a problem that the Commonwealth now wants us to trust Google search timeline after working so hard to prove searches as untrustworthy? So we'll have to see exactly how it comes out, but we've said that may be a problem they're going to have to deal with in the future. He was also in trouble for selling fake Warhols on eBay. Not the sharpest tool in the shed he is. Yeah, I don't know about all of his background. It's kind of nasty. Brian's lawyers argue insufficient evidence for premeditation or extreme atrocity, seeking dismissal of the M charges, questioning MSP Proctor, but Brian does have rights. He absolutely has rights. And again, I don't know everything that happened leading up to this. So I don't know about his prior charges. I know they keep mentioning the other federal charges, but I don't know everything that happened prior. Uh-oh. Narrator, the judge misrepresented the facts. Uh-oh. Okay. Well, then the defense has their job cut out for them, right? If the judge is going to misrepresent facts in the order, I don't know this to be true, but we're going to keep our eye on this case now, right? We are going to keep our eye on this case and see exactly what happens and where it goes. Will you guys hit the like button for me? Will you let everybody watching this case know we're taking a look at it? So if they have questions and they want me to follow it, they will know about this video, our first introduction to the Brian Walshe case. Because if enough people are interested, we'll keep talking about it. If you want me to move on to another one, keep me posted with that as well. I'm looking for a good overview document or video on the Aaron Spencer case, so that I can either play the video, react to it with you guys, talk about some of the facts being reported on it and where it's going. Those are the two. This one and Aaron Spencer are the two I have my eye on with the most interest from you guys right now. All right. 36-page document knocked out. I appreciate you guys all being here. I appreciate you taking the time to hit that like button and subscribe as well. If you guys have not subscribed already. But that's all we got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.